Hello the world, hello the internet, hello to Jason Isaacs. I'm Paul and this is Paul Talks Politics, where Paul talk politics. Yeah, kind of works that way. So hello again. After a couple of interesting videos, I've decided to go for something slightly less controversial. And we're going to talk about the US Supreme Court. So that's going to be good. This is going to be for people who are doing A-level politics, maybe a few people out there doing degrees, or people who just generally are interested in how politics works. Couple of points of housekeeping before we go forward. Sorry about the tash. I'm still doing Movember. You've still got time to donate, so please do donate to Movember. It's a very, very valuable, very, very worthy cause, and the link will be in the description of this video. Also, second about the eyes, I have an eye infection. I'm not collecting any money for that, but if you do want to give me some money, then I'm not going to say no. That's probably about it. We'll get back with the American Supreme Court right after the intro, and so cue the music and see you in a few minutes. And we're back. That was nice, wasn't it? Right, so the Supreme Court. Full disclosure, I am going to geek out totally at this point. Certainly the Supreme Court is one of my favourite subjects. Anyone who's ever had the terrible misfortune of being taught by me will tell you that I do tend to go quite hard on this one. So let's crack on. I'm going to start off with a little bit of comparative theory. Just to sort of lay out the terms. And there's some bits of this that are really important. It's really a good idea to grasp from the get-go. In theory, certainly in America, so again, de jure, if you like, the separation of powers and checks and balances assigns equal powers to the three offices of state. So your judiciary, your executive, and your legislative, three houses both like in majesty, if you like. What we're going to go on and to discover is that because of the way in which the Supreme Court's powers are organised, in real terms, the Supreme Court is quite easily the most powerful of the three. Admittedly, the Supreme Court can't invade a small country or indeed send the entire world into nuclear Armageddon. But, excuse me, when it comes to shaping the civil state in the United States, the civil court is the final arbiter, the final architect, if you will, of the civil state. That contrasts very interestingly with the United Kingdom, where we have a parliamentary democracy, and the concepts of parliamentary government, parliamentary sovereignty, and the rule of law clearly establish that Parliament is the dominant power in our system, and quite right too, because that's the only one we vote for. So in theory, Parliament is the highest authority, while the court's job, and I think you will remember this from my previous videos, the role of the courts in the UK is to uphold the will of Parliament. Now, of course, we know that de facto in the United Kingdom, the government holds all of the power because government controls Parliament, and obviously if you control the dominant power, then you become the dominant power, if that's not a contradiction in terms. But very, very important to see from the get-go that in the UK, the court is subordinate to Parliament, whereas in theory, at least in the United States, the court is on an equal footing with the other offices of state. Though, of course, in real terms, as we discussed, because of the way in which the powers are organised, it operates outside and above them. Judicial review in the United States is assessing the constitutionality of state actions, whereas, of course, in our case, it's assessing the legality of state actions. Perhaps most importantly, however, the Supreme Court in the United States has, by default, effectively, a political role, whereas in our experience, the Supreme Court and the entire judicial system effectively remains neutral, independent, and expert. So, neutral, independent, and expert in the United States, independent, largely expert in the neutral, independent, and expert in the UK, completely independent and largely expert, but definitely not neutral in the United States. So that's just a sort of introductory bit of comparative as we go in. Again, a little bit of background here. So the Supreme Court is described in Article 3 of the Constitution. Blah, 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 blah. This is straight AO1. You can read this. Hey, you can even look at the Constitution if you really want. The most important thing is actually what's not there. If you go into the Constitution, you will see absolutely nothing about judicial review. It is not there. The Constitution made no provision for the interpretation of the Constitution. And actually, one of my kids the other day, you know who you are if you're watching this, said, well, hang on a minute, doesn't that mean that it defaults to the states? Which was a really nice idea. I didn't actually know the answer to that, so I just kept going. That's what teachers do, by the way. You just keep the ball rolling. It's rather like Trump. You just keep the ball rolling, keep the ball rolling, keep the ball rolling, and hopefully you'll get to the some sort of point where you're on firmer ground at some point in the not too distant future. But no, in the United States, the Supreme Court is, or rather, there is nothing about the judicial review. Instead, the whole system of the Constitution really describes the whole judicial system, and it looks kind of like that. Now, do you need to know that? Not massively. Certainly not in the in a UK politics course. In the United States, yeah, very probably that you will. But what we're interested in is the nature of the court and its role. So here we go. There's the court, and here's two types of cases: appellate jurisdiction, which is judicial jurisdiction that's come up through the judicial process, through the appeal process, that ultimately winds up in the Supreme Court, and the vast majority of the caseload that the court has comes up through the appellate pipe. Then you have original jurisdiction. These are cases that go directly to the Supreme Court, and you can see there disputes between the states, cases in which the state is a party and suing a citizen of another state or federal government, or something along those lines. Very, very few cases of that nature turn up, go straight there. US versus Texas in 2016 would be one. Oklahoma versus Colorado would be another one. That was 2015. So yeah, there is some cases that go straight to the Supreme Court, but most of them come up through the appellate route. In terms of membership of the court, now this is not set in the Constitution. Essentially, it's just settled at 9. Sometimes it was more, sometimes it was less. Those of you who've done history will know that this came up in FDR's administration, where we had the switch in time that saved 9. I'm actually teaching the New Deal again for the first time in ages. And interesting, coming at the New Deal and looking at it from the perspective of a politics teacher now, and saying, well, actually, everything that Hoover did was right. He didn't have the constitutional authority to do anything. All of the stuff that FDR later did was constitutionally dubious, which is why the Supreme Court was so against it. But then Roosevelt threatened to expand the Supreme Court to get past those objections. We've also had objections noted by Biden when it comes to the size of the court. There was talk that Biden might actually use his power of appointment or nomination to try to get more justices onto the court to compensate for the chicanery that we'd had under Trump and Mitch McConnell. But anyway, I digress. The key thing here is that we've settled this. It's not necessarily in the Constitution, but it's settled by practice. The appointment process is described in the Constitution. We have a nomination by the President and ratification by the Senate. These are part of the powers of advice and consent, and so one of the reasons why the Senate is, of course, the senior house. It gets to ratify judicial appointments. Current Justice is Chief Roberts. Unusually for Roberts, he came in as Chief Justice when he didn't actually come in. He was nominated by Bush 43, and between his nomination and his acceding to the court, Rehnquist died, and in one fell swoop, Roberts was elevated to the position of Chief Justice, and so he actually sat first time as Chief Justice. Now, the Chief Justice has a number of powers. He doesn't actually have any more power than any of the other courts. It's really just administrative details that he deals with, and he does get to decide who of the justices writes any decisions, but that's a minor detail. What's much more important is that you cannot get rid of a Supreme Court justice because you think he's doing a terrible job. He or she is doing a terrible job. You can only get rid of a Supreme Court justice if, like a president, they're found guilty of high crimes, treasons, and misdemeanors, and then you've got to go through the whole impeachment process. And unlike presidents, we haven't had. Well, I suppose we have had. No, I digress. We haven't had any Supreme Court justices impeached. And I think only one or two judges in the entire history of the United States have been successfully impeached. But I'm sure that someone out there will correct me. The most important point is that no Supreme Court justice has ever been impeached. So it's very, very difficult to get rid of a Supreme Court Justice. So here we have the Roberts Court. Again, do you need to know this? Well, why shouldn't you? You're doing American politics, so you should really know who is on the court. And this is they. So as I said earlier, Roberts went in as Chief Justice in 2005, and the rest of them came in over the following years. Apart, of course, from Thomas, who is a throwback to Bush 41, and he's now comfortably the oldest of the Supreme Court judges, but it doesn't look like he's going to be going anywhere anytime soon. So, that's what the court looks like. You need to know that just by way of background. Always interesting to look at the Senate vote. Again, once upon a time, the Senate vote was significantly less partisan than it is now, and you can certainly see that there with Bush, and even to a certain extent with Sotomayor there in all of that. But subsequent to that, things have got a lot more partisan. The business there with Thomas was more to do with personality, or indeed with allegations of sexual assault, than it was to do with partisanship. But we'll maybe address that in a little minute. In fact, we'll address it now, because there we have Clarence Thomas. That was a controversial appointment, largely because of allegations, as I said, of sexual assault. That was a long and complicated ratification process, but eventually he scraped through. Again, that was, if I remember correctly, a Republican Senate. This one here in 87, again, it was a Republican Senate, he said. But Bork was considered to be too conservative, even for a Senate that was dominated by the Republicans. So he didn't make it through the ratification process. So the job of the ratification process is to weed out the inappropriate candidates. And I've just realised that I've got one here that is missing for that very reason. So Bork was rejected because he was perceived, even by the Conservatives, to be too radical and conservative. And after that, he was the next cab on the rank. Was a gentleman by the name of Ginsburg. He was nominated by Reagan. He then withdrew his nomination because it transpired that he'd smoked dope at university, so he withdrew his nomination. And then third choice up was Anthony Kennedy. Now, this is very, very important later, because just remember that Kennedy was the third choice after Bork was canned and then Ginsburg withdrew. Clarence Thomas there in 1991, a controversial nomination for different reasons, for reasons of personal impropriety. The one that's missing from here is 2005, and that's Harriet Miers. Now, that was an appointment by Bush, 43, and she was rejected by a Republican Senate because she just didn't have the credentials to get onto the Supreme Court. So we see there the Supreme Court being subject to not just political matters of ratification, but also general competence. In fairness, most Supreme Court justices are very well qualified for the job. Harriet Miers was an aberration in many ways. But again, bear that one in mind, because it can come up if you're looking for in instances where the Senate has actually done a half decent job and weaned out inappropriate candidates. From the Senate doing a good job, we get on to the Senate doing an absolutely terrible job. Gorsuch, by all accounts, a very, very decent and reasonable justice. That's not the problem. The problem is that he came in December, I think it was, to replace Scalia. Now, the thing is that Scalia had died in the February. So Scalia died in February 2016. That was obviously on Obama's watch. And so Obama had the right to nominate the next Supreme Court justice. And he lined up Merrick Garland. That was then taken to the Senate. So here we're still sort of spring, early summer 2016. The election's not till November. And at that point, Mitch McConnell said, no, we are not going to ratify any nomination from a lame duck president. And there was a massive hoo-ha, and nothing came of it. On this occasion, Mitch McConnell was clearly thinking, if we replace Scalia with a Democratic nominee, this is going to significantly alter the balance of the court. At that point, nobody really expected Trump to win. But, you could either get that nomination from the Democrats now, or you could wait and see what happened in the election. Unlikely as it would be, Trump could maybe win, in which case he would have the right to fill that particular seat on the court. We all know that Trump did win in 2016, much to everybody's surprise, and straight away we had Gorsuch being nominated to the bench and being ratified in fairly short order by the Senate. Kavanaugh was another critical nomination, or where his personal credentials were on show. Again, more allegations of sexual impropriety, but scraped through the Senate process, 50 to 48. If you do get the chance, look up his nomination, his ratification hearing. It's hilarious. I mean, the things that were going on there, it's just absolutely mental. But don't have time to look into that there. But again, another controversial nomination, ultimately ratified by a very partisan Senate. Then we get into the next one. Now remember that Gorsuch was nominated to replace a justice who died the February before the November election. We now come to 2020, and in this case we have Ruth Bader Ginsburg, who dies in September before the November election. Now you'll remember that in February spring 2016, Mitch McConnell said, no, we are never going to ratify a lame duck nomination. Well, here we are, we're September before the November, and Mitch McConnell goes, yeah, come on, let's get this through. And so Amy Coney Barrett was rushed through the nomination process and the ratification process, and landed on the bench, before the year was out. So, go figure. Is it a political institution? Is it a judicial institution? I'll let you guys think about that. It's a political institution. Right. Road to SCOTUS, how important is this? Not massively, but it does help you see where they've all come from. And again, we talked about experience. Harriet Miers, again, that key nominee from 2005, Bush 43, who lacked that judicial experience, and so was rejected even by a Republican Senate. Right. Another interesting thing that comes up when we're looking at nomination, in addition to expertise, are things like identity politics. Now, I use the acronym RAGES for religion, age, gender, and ethnicity, and sexuality. I really don't want to go into this right now, but all of these things come up when you're looking at the nomination of the Supreme Court, to nomination to the Supreme Court, and getting a balance right and getting a mix right is something that matters a huge amount to certain parties. I'd rather put someone there with talent, but I understand that there are constituencies that judge a person by who they are rather than by what they do, and that is all I shall say on the matter. Thank you very much. Now, you'll remember that way back when I said the single most important thing about the Constitution is what is not in it. And what is not in it was judicial review. Judicial review instead was established by precedent. In 1803, there was an argument about nomination and ratification and who should precede who. And it wasn't immediately clear what the Constitution said. So we needed somebody to arbitrate the Constitution. And it kind of fell to the Supreme Court by default. So in Marbury versus Madison, the Supreme Court took upon itself the right to say what the Constitution actually means. And they have been doing that ever since. Now, that's all well and good. The problem, however, is that if you've got a power that's not in the Constitution, then by definition, it is outside the constitutional system of checks and balances. You look at all of the other powers that we've got in the Constitution. You've got legislation, you've got control of the military, you've got tax raising, you've got all these other different powers. Each of those powers comes with a check. Ambition must be made to counter ambition. Again, that's Madison. The Supreme Court's power, judicial review, is not in the Constitution, and therefore there is nothing that anybody can do to check it. Well, I say nothing. Practically, there are two things. So de jure, there's nothing you can do to tackle or challenge a judicial decision. De facto, you've got two options. The first is to amend the Constitution. And this is the argument of a certain school called originalism that I'm going to deal with in the next video, where I really do geek out in a very big way. The second thing you can do is wait for the court to change and then try again. Now, the last time the Constitution was changed in response to a Supreme Court decision, well, you can see it there. It was the 16th Amendment. We're now on the 27th, in case anyone's counting. And that was against the case in 1895, and it took them another, 18 years to change the Constitution. And this was to do with, if I remember correctly, the right of the federal government to raise income tax. Because it's so hard to change the Constitution, that's one of the reasons why we tend to get into this situation whereby the smart move is to wait for the composition of the court to change and then try again, which kind of again shows that it's a political court. But we'll get to that in much more detail as we go through a few case studies in a little while. So that's what judges do. Now let's have a look at one of the key ideas here, and that is judicial neutrality and judicial independence. Yep, sorry, just had to take a brief stop there to replenish my juice, so stay hydrated, kids, all right? Okay, neutrality and independence. Yeah, God, I love this. Okay, let's deal with independence first, because independence is easy. Is the Supreme Court independent? Yes, it is. Once you put a justice on the Supreme Court, they're very, very difficult to get out. They're like limpets. They're just going to stay there until they are called to the celestial bench. In fact, recently it's become more common for Supreme Court justices to resign. So, for instance, Anthony Kennedy resigned, making sure that he resigned under a Republican administration. He thought that was fair because, he'd been appointed by a Republican, and so he was going to resign on a Republican's watch. That was his decision, and we just have to live with it. But the main point is, if Supreme Court justice has been put on the bench, there is nothing a president can do to influence their decision or to change their mind or to yank them off if they think they're doing a terrible job. That's the most important point, really, about independence. And then all of this stuff is really just detail. That's the real bit there. You can't get rid of a Supreme Court justice if you think they're doing a terrible job. And I'm going to go into that in a bit more detail in a minute. Now I'm going to talk about neutrality, and I'm going to make a very controversial statement. Is the Supreme Court neutral? Well, yes, it is. But only in the long run. The idea is that if the White House changes hands on a regular basis, and if the general pattern of appointments follows the normal run of things, then over time the Supreme Court will be neutral, as you have Republican presidents succeeded by Democratic presidents and so on and so forth. Now, that's a really cheap shot, to be brutally honest, because the single most important thing to remember here is that if it's neutral in the long run, then at any given time, the Supreme Court is going to be biased one way or the other. Now, for the longest time, when I was studying politics at school and then again at university, and even when I started teaching politics, there was essentially a progressive majority on the Supreme Court. Under Trump, that has changed. We now have a conservative majority on the Supreme Court, and that, I'm afraid, is just the way it is. When a president is appointing a justice, they will take those political qualities into account. Now, the professional qualities are generally a given. And again, remember Myers from 2005. She fell short of that, and as a result of that, her nomination did not proceed. Politically, we're going to be looking for people who share the same sort of judicial philosophy as the president who appoints them. Because the consequences of getting that wrong is that you are stuck with a Supreme Court justice who is making decisions with which you, as a president, do not agree. Now, I always find it very, very useful to make sure that at this point you're talking about progressives and conservatives, rather than liberals than conservatives, because of course liberals has a different connotation, and then you've got liberalist as well, and it all gets very confusing. Do not talk about Democrats and Republicans on the court, because that's not fair. They are not Democrats, they are not Republicans. They might be appointed by Democratic or Republican presidents, and Clarence Thomas might push the line really, really hard. but we shouldn't call them Democrats or Republicans. Think instead of the justices as being progressive or conservative. And they will be nominated for that ideology, and that will be part of their ratification process. They will be asked questions about where they stand on this matter, that matter, and the next matter: abortion, drugs, voters' rights, all of those sorts of things. And so the nomination process and the ratification process is avowedly and openly political, and more so recently. And again, you go back, and I do urge you to go and watch that nomination process with Kavanaugh, where it gets really very, very heated and very nasty on all sorts of fronts. So when the nomination is being made, they're going to be professional qualities and political qualities, both of those combined, to create your ideal justice. Now, here we can see a representation of the decisions made by Supreme Court justices. Now, this is a huge science that goes into this. I didn't prepare this slide, but somebody else did, and they spent a long time evaluating lots of decisions and calculating massive matrices, and this is what they've come up with. And so you can see essentially how the median court, this is how the court generally, this yellow line here is how the court has tracked, or how the sort of median justice has moved. But within that, you can see how individual justices have also moved. We've got a conservative line, we've got a progressive bit at the bottom there, and we can see how some of these judges, like Stevens here, was started sort of fairly. Why didn't I change the color? How do I change the color of the pen? Let me maybe do that. In fact, what I might do is I'll go for a highlighter instead. And I'm going to go for green. So we can see Stevens here, who has started relatively centrist and then tracked progressive. Another one who did that was Ginsburg, got increasingly progressive. But then also people like Souter. We can see here what they call liberal drift. On the other hand, you've got people like Thomas and Alito, who are heading distinctly in the other direction. Roberts is a really interesting one. He starts quite conservative and then gets more progressive. Kennedy, as we can see there, remained pretty consistent, and O'Connor just a little bit below that. So these individuals are making political decisions. They are making either conservative decisions or they are making progressive decisions. And having been put on the court, they are there until they decide to leave, and they will keep making those decisions until they don't, I think is the short answer. And that's why there is so much care and attention made or paid to appointments to the Supreme Court. If you get it wrong, if a president gets it wrong, then they have to live with that decision for the rest of their administration. Now remember, a president's maxed out at 8. Okay, Stevens was on there from 75 until 1980. I think it was longer than that. I might need to check my... that's not right. Yeah, much longer. Yeah, sorry, to 2010 by the looks of it. So Stevens was... I'll have to... Sorry about that. Whoops. I'll fix that later. Fix it in post or something. So Stevens was on there from 1970 until 2010. Which is a very, very long time, as I'm sure you can work out. O'Connor was on there for... basically your Supreme Court justice is going to outlive your presidency by some distance. Now, SOX here. These are instances where a president has nominated a Supreme Court justice and they haven't behaved the way that was expected. So let's just go back here. We've got Stevens. Stevens nominated here in 1975 by Ford, and Ford, of course, being a Republican. And look what Stevens does. There we go, all the way down there. O'Connor, we've got her here. She comes in the latter years of middle of the Reagan administration. So where does her line start? But anyway, she basically goes in that direction. Kennedy, again, in that direction. That's another Reagan appointment. And finally, Souter there by Bush. These are instances where a justice has been appointed and they have not essentially behaved in the way in which the president expected. Stevens, straight up mistake. I can't really explain why that happened. O'Connor, the reason why O'Connor turned out to be more progressive than Reagan perhaps anticipated was because, of course, Sandra Day O'Connor was the first woman on the Supreme Court, and this was the least progressive woman that Reagan could find. Kennedy, remember, he was third choice after Bork was rejected and Ginsburg withdrew, and then Kennedy came along, and he turned out to be nowhere near as conservative as Reagan had hoped. And then Souter, that was a straight up mistake by Bush 41. Now, at that point, a very interesting organisation called the Federalist Society suddenly swung into gear, and they said, right, this cannot be allowed to happen again. The president's single most important legacy here is the Supreme Court, because the Supreme Court is the final arbiter of policy, the final architect of the civil state. And if you're appointing somebody who's going to be around for a good 45 years, as in that case, that's not a mistake that you really want to make. So the Federalist Society has assumed responsibility for identifying, training and vetting potential candidates to the Supreme Court bench from the conservative side of the equation. And all of the nominations since Souter have, on the Republican side, have been created, ratified and pushed forward by the Federalist Society. When Trump was parading his list of Supreme Court names when he first came in, each and every single one of those had been given to him by the Federalist Society. So this is probably the single most important pressure group that you've never heard of until now. So consider yourselves fortunate. Of course, if you did know about that already, apologies for trying to teach you to suck eggs. This is, again, another one of those representations of where judges are on the ideological spectrum. Remember that Clarence and Thomas, Alito and Thomas have kind of drifted out to the right of late. Does this matter? Well, for your own satisfaction and curiosity. Roberts is the one that's going to be very, very interesting to watch as he inhabits what's left of the centre swing ground. And he has come up with some very interesting decisions. Well, one particularly interesting decision in the shape of Sebelius. And again, we'll get onto that in a little while. Just before we leave independence and neutrality, I thought I'd show you this slide. This is all about independence and neutrality. Hopefully, it's going to show you here how the court is not neutral. And so we've got progressives on the blue, we've got conservatives in the pink. And you can see there how the line shifts over time as people get recycled on the Supreme Court. Also here in red, you can see our Sox friends. And you can see how Stevens comes in here and he hangs around for another 45 years until he is eventually replaced in 2010. So that was not the original plan. When Ford nominated Stevens to the bench, he did not anticipate him being a progressive judge for the next 45 years. Those of you who've done your history and your civil rights cases will know that Eisenhower considered his nomination of Earl Warren to be the biggest damn fool mistake he ever did make. And the Warren court, again, a Republican appointee, turned out to be a highly progressive court. Here we can see O'Connor, and she was a swing justice. Sometimes she went a little bit that way, sometimes she went a little bit that way. Kennedy, similarly, a swing justice for a long time. Kennedy lost one case in all of his time there. One case of any great significance, and we will come to that. That was Sebelius. That was the Obama case. But in virtually every case between his nomination or his ascent to the bench in 1989 and his resignation under Trump in 2018, Kennedy was the fifth vote in every 5-4 vote. Here we can see the two gaps left in the court by the machinations of Mitch McConnell, refusing there to nominate Merrick Garland, to nominate or to ratify Merrick Garland, and refusing to nominate Merrick Garland, and here rushing through the nomination of Coney Barrett to consolidate that conservative majority on the court. And you can see again there how the court shifted under the Trump administration. That was just the way the ball bounced, to be brutally honest. The progressives had a majority on the court for a long time, even though we'd had majority Republican presidents. Because of those four mistakes, because of Sox, even though we had Republicans in the White House for the majority of that time, we had a progressive majority on the Supreme Court, which was, for someone who is a progressive state of mind, that's a good thing. Obviously, if you're a conservative, you're going to see things very differently. So yeah, that's it on neutrality and independence. But we now need to think about how the judges themselves look at the Constitution. And here we're going to introduce a few key terms. We're going to look at originalism, living constitutionalism, and strict and loose construction. Now, as far as you're concerned, loose construction is essentially the same as living constitution. Fortunately, they both begin with LC, and so hard to get wrong. Originalism is a judicial ideology that suggests that the Constitution should be looked at in the context of the time in which it was written. Strict construction says that you should just look at the text. Just look at the text, the whole text, and nothing but the text. Now, in my next video, I go into strict construction and originalism and loose construction in much more detail. As I said, I really geek out on it. What you need to know at this point is that strict construction is an ideology that will drive you stark staring mad. It doesn't work. Nobody is a textualist. Another word for this is textualist. Nobody is a strict textualist because you can't be, because the Constitution is just too vague and too badly written to allow that. Originalism is that ideology, as I said, that takes the text and then puts it in context. The idea being that if you stopped one of the judges, or one of the founding fathers even, as they were walking down the street, if that were ever possible, and you asked them a question about what they thought about a particular issue, then that answer would be an originalist intent. Again, I talk about this in much more detail in the next presentation, so I don't really want to get into too much detail there. The living constitution is about stretching the Constitution so it will fit, and that idea, the evolution being a dynamic entity. Obviously, if you can't amend the Constitution, then living constitutionalism is vital. Otherwise, essentially, you're rooted in 1789. But again, I'm getting ahead of myself, and I really want to look into this in the next presentation. So do come with me on that one. But I wanted to introduce those there. So you need to know about strict construction, originalism, and loose construction, or living constitutionalism. A little bit more about that there. Originalist tends to be conservative, living constitutionalist tends to be liberal, and you can read all of that there. I don't know why I've got that in. That's party of nomination rather than strict party. Constructionist. Clarence Thomas is as close as you can get to a strict constructionist, but even Clarence Thomas recognises that there are some areas in the Constitution that need to be interpreted. Ginsburg there recognised as an arch loose constructionist. Activism and restraint is another thing that you need to get your head around, and it can seem quite complicated. Let's put it this way. Judicial activism says, look, sometimes mistakes are made, and if a mistake is made, then it is the obligation, or rather there is an obligation on the Supreme Court to correct it. Now, usually this is associated with progressivism, but that's not always the case. We can have judicial activism of a conservative nature, because what we're saying is, essentially, if we've got judicial activism, here is the decision. Whether it's precedent or it's a law or it's anything else, here is the decision. If the judges come along and they knock that over, then we have activism. The judges have actively changed a decision. They've actively either struck the statute from the book, or they've overturned activism. It could be progressive, it could be conservative, it doesn't matter. It's the action that is the important thing here. Judicial restraint is inevitably the opposite of that. So here's the action, and the judges go, no, let it stand. Stare decisis. Let it stand. And again, sometimes that can be conservative, sometimes it can be restrained. So we're looking here at the action rather than the motivation. If a conservative judge knocks down a progressive law, then that is activism. If a If a progressive judge knocks down a conservative law, then that's similarly activism, and vice versa. If a progressive judge holds up a conservative law, that's restraint. I think I've made my point. So think about the action. Are you knocking it down? If you're knocking it down, then you're active. If you're creating change, then you are active. If you are letting it stand, stare decisis, then that is restraint. Don't overcomplicate this. This is much simpler than you might think. Activism is not necessarily progressive. Restraint is not necessarily conservative. It's the action of the upholding or the striking down. In terms of SCOTUS and the Constitution, the areas where SCOTUS gets involved, the areas where SCOTUS tends to find itself drawn into making these decisions will be questions about federalism, and particularly questions involving the Supremacy Clause and questions about the Commerce Clause. The Commerce Clause, again, another favourite bit of mine. The Commerce Clause is a stretchy thing that's been stretched and squeezed and so on. And oftentimes we'll find the Supreme Court has allowed the federal government to act under the Commerce Clause. So if we look at Katzenbach versus McClung, for instance, those of you, again, who have done civil rights will know that this was the instance where the Supreme Court used the Commerce Clause to uphold federal legislation desegregating private businesses. For those of you who really want to know, there's an amazing podcast on this, which I'll try to dig out because it's fascinating. But this was to do with interstate commerce in tomato sauce. Now, what has interstate commerce got to do with tomato sauce? Absolutely nothing. But the Supreme Court recognized that this legislation was required in order to desegregate restaurants that were, the government could desegregate schools, hospitals, army, all of that. It couldn't desegregate private businesses. And the Supreme Court on this occasion, under, again, the Warren Court, they wanted to be on the right side of history. And so they upheld this legislation that was using the Commerce Clause to desegregate restaurants and other private businesses. The reason why that becomes really interesting is because in Morrison versus US in 2000, the federal government once again passed legislation seeking a progressive end, on this case violence against women. There'd been a sexual assault on a campus, I think in Virginia. And the alleged perpetrators had got off very, very lightly, and because the state law was not robust enough. So the federal government passed the Violence Against Women Act. And that was, they said, look, we're going to pass this on the grounds of the Commerce Clause. And they went, what, how on earth can we? They said, well, look, it's just like Katzenbach versus McClung. If you've got racist restaurants that are either drawing in racists from outside the state or dissuading or persuading people who are suffering from racism to go outside the state, then you've got state commerce. The argument in Katzenbach versus McClung, for those of you who know, will also involve tomato sauce, but that's a whole different story. In Morrison, it was like, look, if you've got soft laws of violence against women in one state and stronger laws protecting women in other states, then women are going to go to that state for their university, which actually seems kind of a more plausible argument than Katzenbach versus McClung, but it was struck down as an unreasonable stretch of the Commerce Clause because the Supreme Court, as we got into the 2000s, into the later years from 2000 onwards, became increasingly sceptical of the use of using the Commerce Clause to achieve progressive ends. Whole different argument, one to worry about when you get to university. Maybe I'll do a presentation on that later. It's rather like my American version of the death penalty, of the whole life tariff in the UK. Government powers, the elastic clause, to what extent can the government use its power to do other things? Again, not massively interesting. It does come up from time to time, but the elastic clause is not one that generates a huge amount of controversy. But here we've got the Bill of Rights and due process. Between that and the Commerce Clause, you're going to find most of the significant cases that are going to help you navigate any essay on the Supreme Court going forward. So you need to know your cases about Bill of Rights, due process, equal protection. Learn your cases. With the Commerce Clause, you've got Wickard and Philbin, you've got Katzenbach versus McClung, Morrison versus US 2000, and ultimately Sebelius versus National Board of Federated Industry, NFIB, National Federation, NFIB of 2012. Yeah, so let's put Sibelius in there as well. Sibelius. Now, when we're looking at those enumerated rights, again, there are rights, as it says there, not easily identifiable in the Constitution that are still held to attend. You'll know from your Constitution that the 9th Amendment says basically if a right isn't listed here, that doesn't mean it doesn't exist. So rights not enumerated should not be held to, well, I can't remember what it is. But what the Supreme Court has done is that it has said that there are a set of rights not explicit in the Constitution, but that are still either deeply rooted in the nation's history and tradition. That was a phrase that came up in Moore versus City of East Cleveland, or implicit in the concept of ordered liberty, came up in 1937 in Palco. And the court has used those phrases to identify certain rights not in the Constitution that nevertheless the people can be understood to hold. And of course, the single most important one of all of these is Griswold. Griswold was the first of these big, one of the massive civil rights cases of the 60s. Again, we're looking at the Warren Court. And here, the Supreme Court recognized an implicit right to privacy. Specifically, they said if you take the First and the Third and the Fourth and the Ninth Amendment, then somewhere in the middle there, you can identify an implicit right to privacy. In this case, it was specifically what married couples got up to in the marital bed. The state had no legitimate interest in that. And so Griswold versus Connecticut in 1965 established a right to privacy. In 1973, that right to privacy was extended not only to a woman's reproductive system, but also to the discussions that she might have with her obstetrician or her gynecologist. And then that allowed a platform on which Roe versus Wade could be built. So again, that was a right not easily identifiable in the Constitution, but one that existed in the implicit clauses elsewhere, covered by implicit in the concept of ordered liberty or deeply rooted in the nation's history and tradition. Specifically, they're looking at privacy. Lawrence versus Texas argued that consenting sex between adults was not a legitimate concern of the state, and used that to strike down Texas's sodomy laws. They're still on the books, if you really want to know. They're just unenforceable. Now, again, we're looking at the right to privacy. We're looking at due process, that 14th Amendment saying that all people are equal under the law. So what straight people can get up to, gay people can get up to. So again, privacy, full substantive due process, all of those together. And then that substantive due process, so 14th Amendment, particularly on these ones, allows the court to recognise, the right for gay sex to happen and the right for gay marriage to happen. And so none of these rights are written in the Constitution, and yet the Supreme Court has identified them as being implicit there by looking at specific rights that do exist, particularly 1, 3, 4, 9, 13, 14, 15, and extrapolating them and stretching them so that we can get a constitutional fit. Of course, the problem is that if they're not there, then there is the opportunity for future courts to come along and strike them down. And indeed, that's exactly what's happened in Roe versus Wade with Jackson versus Dobbs in 2022. So the Supreme Court has come along and said there is no implicit right to abortion in the Constitution. So they've got rid of that one. One wonders which one they might be going for next. So that's Jackson versus Dobbs. All of which brings us to this fundamental decision or question. Is SCOTUS political or judicial? Well, hopefully by now you've realised that it is a political body. Why is it a political body? Because the appointment is political. Judges are put there for political reasons. Now, of course, you can argue that there is the threshold of competence that they also have to pass, and that's perfectly valid. But we know that the president appoints them to do a political job and the Senate will ratify them to do a political job. And this has become ever more so since the debacle of SOX over the 80s, 90s and into the noughties. Now, in the rational side of things, how do judges make decisions? Well, again, I'm going to go into this in much more detail in my next video. The key thing there is that liberty finds no refuge in the jurisprudence of doubt. That's a lovely phrase that I'll explain in the next video. This is all about originalism versus living constitution. What does the constitution mean? Are they making judicial decisions? Are the judges making political decisions? And I think you probably know the answer to that as we go through. And the third and final aspect of this is the cultural element. This is to do with the sort of questions that the judges are being asked. If the judges are asked decisions of law, then they're going to come up with legal answers. However, if they are asked political questions, then they're going to come up with political answers. And the key thing there is Baker versus Carr. Now, we've mentioned the Warren Court a few times now. Earl Warren was asked what was the single most important case that he heard in all of that time. Now, bear in mind, we've just looked at him. We saw earlier that in 64 we had Katzenberg versus McClung, and in 65 we had Griswold versus Connecticut, and then you've got Miranda versus Arizona, and various other critical landmark cases in civil rights. However, the most important case that Earl Warren thought that he had heard was Baker versus Carr, because he said this was when the Supreme Court entered the political thicket. That was when the Supreme Court started answering political questions. And once you're in the political thicket, it's very, very hard to get out. And we can see that now. We can contrast that with the United Kingdom. In the United Kingdom, in Nicholson versus Ministry of Justice 2014, our Supreme Court was asked a straight up political question. And they went, no, you're going to have to take that to Parliament. We are not going to answer that. Parliament is better placed than we are to answer that, because that is a political question. And if you're asking a political question, then you want to make sure that whoever answers it and gives you a political answer is democratically accountable. And SCOTUS isn't. Neither is our Supreme Court, but our Supreme Court demurred. They declined to answer that question. They said, you're going to have to take that to Parliament because this is a political question. The Supreme Court in 1962 answered a political question, and they've been answering political questions ever since. Now, if you want proof of that, here we go. So the Bipartisan Campaign Reform Act, or BCRA, McCain-Feingold Act, that was passed in 2002. This was an attempt by, as it says, bipartisan. McCain and McCain, of course, that being Republican, Feingold being Democrat. They passed this bill to try to stem the flow of money into American politics. Now, of course, where money goes, court cases follow. And straight away, that was challenged in the Supreme Court. So in 2003, we see a challenge against the BCRA. That's first challenge, McConnell versus the FEC. And yes, that is Mitch McConnell. Goodness gracious. Now, on this occasion, the Supreme Court looked at the BCRA and said, no, we are going to uphold that legislation. That legislation is constitutional. So in 2003, the Supreme Court looks at the BCRA and says, yep, constitutional, perfectly happy with that. 2008, we get another case. Another case is brought up, and this is Davis versus the FEC. And here we start to see the Supreme Court dismantling the BCRA. It invalidates the Millionaires Amendment specifically, which grants, if you've got some money bags who's running from his private funds, it grants acting cash to any challenger if it exceeds a certain threshold. None of that really matters. What really matters is that we see the Supreme Court coming in and starting to dismantle legislation that was put in place to try to stem the flow of money in politics. The third challenge, Citizens United, which you must have heard of in 2010, the Supreme Court comes in and basically takes whatever's left of the BCRA and tears it up. Actually, there's another case, McCutcheon versus FEC, but this is enough to be getting on with. So in 2003, the Supreme Court upholds the BCRA, says it's perfectly constitutional. That's fine. In 2008, Supreme Court says no, it's unconstitutional. In 2010, it says no, it's really definitely unconstitutional. So what happened? Did the Constitution change between 2003 and 2008? Did suddenly somebody find a new part of the Constitution that they hadn't recognised before? So they could say, oh no, objectively, quite clearly, this BCRA is unconstitutional. Well, that would be the straightforward bit. Although arguably the answer is even more straightforward. In 2005, Alito replaced Sandra Day O'Connell. We went from a 5-4 progressive majority to 5-4 conservative. Well, actually, it was 4-4, but we had Kennedy in the middle, and Kennedy had always found that the BCRA was not to his taste. And so he, on this occasion, went with the Conservatives, and the balance of the court changed the decision. So here we've got a progressive majority, as represented by Sandra Day O'Connor, voting with progressives. Over here, we've got Alito replacing Sandra Day O'Connor, and the Supreme Court goes essentially from 4-5 to 5-4. Therefore, the Supreme Court is a political body. It's indisputable. So, when you ask a body, or when you ask an institution essentially the same question 3 times, and its position on that changes from one question to the other, then the question hasn't changed, the premise hasn't changed. What has changed is the people you're asking the question. And if that is a judicial bench, then that's not very good news, because it sounds like your judges are making political decisions. If you have an independent and neutral judicial body, then it shouldn't matter who's on it. You'll get the same answer because they're the best people for the job. That's how it certainly works in the United Kingdom. That's clearly not how it works in the United States. Between 2003 2008, the Constitution didn't change, but the people who were charged with interpreting the Constitution, they did change. Therefore, the Supreme Court is a political body. And I'm going to go into that in a bit more detail in the next video. That's going to be a deep dive into strict construction, originalism and loose construction. I love this subject so much. If you've got any questions, please do let me know. I know this has been a long video. If you've made it this far, thank you so much. Like and subscribe, questions in the comments, and I will see you in the next video. Thanks for your patience, and good luck, everybody. See you on the other side. Oh yeah, I did mean to say that if you want to get ahead of the game on the next video, do please look at these 2 videos here. I will link off to them. Sorry, podcasts here. I will link off to them in the footnotes. One is about the First Amendment. The second is about the Second Amendment. And they will help massively in terms not just of you understanding this particular aspect of the course, but also the entirety of American politics. So yeah, do watch those or do listen to those, and I'll see you in the next video. Cheers, bye now.